Well, this is a matter in which we had filed an amendment application
अच्छा
challenging the two notices which amendment was allowed, notices of 15th October and 23rd October, in which they were asking for the Google ID and password. And I submitted before your lordship that this is in violation, this is a phishing inquiry in violation of right to privacy. Now there are in fact an order of the Supreme
have
Court
challenged
itself.
that notices also.
Yes, we've challenged, and that amendment was allowed by your lordships.
Right.
And now, so now, in fact, there is an order of the Supreme Court dated 13th of December, which we can hand over to your lordship by Justice Oka, in which, in a similar matter, the court directed that respondents should not get access and copy of contents of mobile phone of the applicant. And an ex parte ad interim order has been passed staying that. I hope your lordships have that order.
Yes. This pertains to some other case, I suppose.
That's true, but I'm just saying because that's the whole point, mothers, that they can't get access through my password to information that's private to me. Unless they tell me what is it that they want, mothers. They can't, because there is nothing against me. I'm not in the FIR. They just called me, I went.
The FIR was lodged against unidentified persons. During the course of investigation, 5 accused were apprehended. 4 are still absconding. He is not a named accused as of now, till date. And the police, wide energy of P5 and P7, has only directed him to provide the Google password. If the petitioner doesn't wish, the police is not compelling him to do so. My lords, may have a look at the language of the notices. Annexure P5
So
and
we
P7.
record your statement that you will not compel him to.
That's all, lordship.
Yes, Mr. Zimbabwe. That is what he himself is saying, that you have not been made an accused and the police has sent a notice. If you don't want to give your password, they will not compel you.
That's fine, no, that's fine with us. That's fine with us.
As per the CRPC, the notice is issued under section 94 of
the
the
issue here, but you cannot ask the accused to furnish an incriminating circumstances against himself.
Definitely.
That is what is their case.
And if needed, if he voluntarily does not give, we have an option to approach the magistrate.
कर लीजिए आप through process of law आइए आप और क्या, that is all और क्या जो है dispose of कर देते हैं.
And for a moment, the language of the old act and the new act, there is a bit difference.
Mr. Probably in this case, when was this case registered?
It was registered in the month of July.
July. More than 7 months have already passed, right? You have not been able to collect an evidence against probably any of the accused.
No, Lordship. Total 5 accused were arrested.
5 तो arrest हो गए, 4 are absconding. तो वो तो अपनी bail हो गई होगी, उनसे तो कोई मतलब नहीं है. The thing is that if you want this person's, if you find any involvement of this person in the present case, you are free to get investigation done. But so far as some personal ID and all are concerned, it is not in your domain to take
because
like
the High Court of Karnataka in one case single has ruled, but there are various Supreme Court judgments which are otherwise.
Celebrated case hai. Mr. Sibbal, one question apart from this case, which we want your assistance.
Sure.
To what extent the privacy can be extended? Supposing a person who is having a special knowledge of a crime being committed, what is the method by which the investigating agency can book him through a
Very simple. Very simple. Nowadays, you have the records of mobile phones that are available with the telecom operator. So if a crime has been committed, the presence of my mobile with me will demonstrate that I was at the scene of crime.
No accused commits a crime with a apparatus which can be easily available to an investigating agency. Supposing he is so sharp, you know the things how the crime are being committed. There are cyber offenses. what
You're
is
right.
the remedy available to the investigating agency to get hold of that accused? You
Well,
are taking,
that's
there is
very
a, as you know, that there may be no evidence, but there is a narco test. For that, consent of the accused is required.
right.
And in that, he has to undergo that narco test. Whether he gives his consent or the consent will be asked, but the accused deliberately knows the fact that if he is put to narco test, then you cannot say that it is an evidence which has been created against the accused.
Well, that's
This is what-
different. That issue is different. But I tell your lordships, for example,
But here, if the accused is so sharp, he has committed a crime like this, and he knows that no one can ask me to furnish an incriminating evidence. Whether the law will be a mute spectator.
no,
This
Manas,
is
I'm sorry, Manas. Let me explain this a bit. Manas.
Yes, just
Manas, I have to ultimately communicate on my mobile phone.
mobile. What they are asking, probably the evidence. They say that the Google password ID you are wanting, na?
There's no evidence for me, Manas. There's no evidence for me. I'm not an accused. There is nothing for me. Nobody has said anything about me, Manas. They just want information. That's about it.
Yes.
But be that as it may, I'll just give your lordships an example. So,
Yes.
Manas, a mobile phone is actually an instrument to communicate.
Right.
Manas, therefore, it's a communication by me to somebody else. Correct, Manas? In the
Right.
course of investigation, if they find that I have communicated to somebody else, it can easily be found out, Manas, that the source of it is me, in which they can ask for my mobile phone.
But supposing the accused knows the fact that if he is communicating on a mobile, he will be easily trapped. But he is using any other mode of electronic record or evidence, which he thinks that ultimately this cannot be, the investigating agency cannot ask me this information.
But Manas, we are talking about a mobile phone now, Manas. We are not talking about any other electronic record.
You have asked for क्या लिखा है इन्होंने?
Google
देखिए
का
जरा।
No, just a mobile phone.
अच्छा, मोबाइल का
P7 में भी seen
जैसा एक बार नोटिस दिखाइए प्लीज।
P7
नोटिस दिखाइए, नोटिस दिखाइए।
page number 25 of the
Page
petition.
25, page 25.
25।
The second paragraph is important.
एक सेकंड, पेज 25। एक सेकंड बस।
जब शुदा मोबाइल का गूगल आईडी एवं पासवर्ड।
अच्छा।
That's what they've asked for.
मोबाइल खोलने हेतु आप स्वयं अथवा किसी अधिकृत सक्षम व्यक्ति को दिनांक सो एंड सो डेट को भेजें।
अच्छा, तो ये मोबाइल गूगल आईडी पासवर्ड है, ये इनका मोबाइल में ही है, तो इसको आप इससे आप कुछ गैदर करना चाहते हैं?
Because that's all, they want information.
And
When they get information.
the Karnataka High Court was posed with a similar question. Although it is a judgment of a single bench, I should not refer, but since my lord has posed a question,
नहीं ठीक है, we are just
the Karnataka High Court single judge framed a question. Can a direction be issued to an accused to furnish the password, passcode or biometrics in order to open the smartphones or the email account? And the answer was in affirmative. The honorable judge has observed that
just a minute, just let
that during the course of the investigation, the investigating officer can always request and or direct the accused to furnish the password, passcode or biometrics, enabling the opening of the smartphone and or email account. It is up to the accused to accede to the said request and or directions. If the accused were to provide such a password, passcode or biometrics, the IU could make use of the same and again gain access to the same. So, Lordship, that's why I am submitting. Since we have issued a notice under section 94, and if the language of the section 94 is seen, it is different from earlier section 91. Lordship,
नहीं तो ये तो
94 का
ये
notice
BNS है कि क्या है? ये तो BNS ही है ना?
Lord, 94
94
of BNS.
CRPC
नहीं BNS
BNS लगे ना?
Lord.
94
Because earlier section 91 read summons to produce document of thing. It is CRPC. Whenever any court or any officer in charge of a police station considers that the production of any document or other thing is necessary or desirable for the purposes of investigation, inquiry, trial, or proceedings under this code. Here I pause, Lordship. And the same thing in the new act is that whenever
94 क्या कह रहे हैं?
94 summons to
BNSS होगा ना?
BNSS.
लगे 94 तो
Section 94 में थोड़ा सा difference है sir.
वो थोड़ा सा उन्होंने किया होगा.
Whenever any court or any officer in charge of the police station considers that the production of any document, now the new word which has introduced is electronic communication, including communication devices which is likely to contain digital evidence or other thing is necessary or desirable for the purpose of investigation. This particular